Okay, good afternoon. Okay, Mr. Kesavan will start. Okay, good afternoon.
Go ahead.
Okay, good afternoon, everyone, for joining. This is a webinar that is organized by MPC Pemuda, supported by FMM, and then supported also by the Malaysia Semiconductor Industry Association. My name is Andrew Chan. I'm from Malaysia Semiconductor Industry Association, MSIA for short. I want to say a welcome to Dato' Andy, welcome to Dato' Sri Wong Siu Hai. Thank you very much, Mr. Kesavan, for doing this and sharing your knowledge with all of us. And also good afternoon to ladies and gentlemen. I will ask that all of you who are not speaking to also mute you. If later if you're not muted, I will mute you from my side. So the agenda for today is that I will let Dato' Sri Wong say a few welcome words, and then we will get Mr. Kesavan to share. He's got quite a number of slides to share. There's a lot of amendments, as I understand, for maybe an hour or so. And then we will have maybe about 20-25 minutes of Q&A. So you will see the chat box there at the bottom. I would encourage you, as Mr. Kesavan go through the slides, if you've got a question, please post it in the chat group. And then when I moderate later, I will pick up your questions and then we will pose it to Mr. Kesavan. Okay. Without further ado, maybe I invite Dato' Sri Wong Siu Hai to say a few words before we start. Thank you, Dato' Sri Wong.
All right. Thank you very much, Andrew. First of all, I'd like to welcome all of you to this afternoon session on amendments to the Employment Act. This has been a long-standing issue with the Employment Act. I know that many people in the industry are concerned about the act and need the act to be changed. And I think today we have Kesavan from FMM, who is going to share with us some of the amendments that are coming up. And hopefully, we can give some inputs and take it up from here to also add voice to what FMM is trying to do. So this webinar is possible because I approached Dato' Andy Seo, who is the co-chair for the Pemuda, and he said that it is good that if we can get FMM to share with us what they have done so far, and maybe MSIA can pick it up from here and also add our inputs to the amendments that's coming up. So I would like to thank both Mr. Andy Seo, Dato' Andy Seo, for helping me to arrange this, as well as Dato' Nathan from FMM, who I contacted, who also helped me to make this arrangement. And also I'd like to thank Kesavan of FMM for taking his time this afternoon to share with us all the work that he has done on this Employment Act, amendments to the Employment Act. So hopefully there will be great sharing, and I'll prepare your questions and we have a good discussion. Thank you very much.
Thank you, Dato' Sri Wong. Before I pass over to Mr. Kesavan to start, let me just say a few words and introduce Mr. Kesavan. Mr. Kesavan is the FMM's Human Resource and Investor Relations Advisor. Before he joined FMM in 2017, he spent 36 years with the Ministry of Human Resources and Ministry of Domestic Trade and Consumer Affairs. And his last position in the government before joining FMM in 2017 was Principal Assistant Secretary to the Policy Division of the Ministry of Human Resources. So when you Google Mr. Kesavan, you see him busy doing public seminar and talking about employment, human resources, etc. A man of a very experienced person in this topic. So without further ado, can I invite Mr. Kesavan to do his presentation? Please, Mr. Kesavan, thank you very much.
Thank you, Mr. Andrew. Tan Sri, Dato' Sri, Dato', Tuan-Tuan dan Puan-Puan yang saya hormati sekalian. A very good evening, ladies and gentlemen, and whoever I've addressed. I will take you all through the Employment Act, whatever amendments that has been proposed. Proposed, please You have to get it. It has been proposed. And the EA, that is the Employment Act, was tabled on 25th of October 2021. That is last year, October, it was tabled. But it was put on hold. It was put on hold to pave way for the government to table the budget 2022. As a result, it was put on hold. And I think this year, during the Parliament session, it will go for its second reading, third reading, and eventually will be passed. If there is no changes or of anything, if there's no changes, then it will sail through properly. Otherwise, then it will be sent to the drawing board, and then maybe further amendments has to be included or maybe polished or whatever. So now, though the EA, if you look, is a 1955 act, even long before I was born, but nevertheless, the Employment Act underwent at least minimum about 11 to 12 amendments all this while. And if I'm not mistaken, the last amendment was done in 2010, if I'm not mistaken. And it has been amended, okay, and throughout these years. Now the EA is amended. This particular EA amendment 2021 is amended to comply with the international standard and practices as required by the TPPA. TPPA is a Trans-Pacific Partnership Agreement, and the Malaysian US Labor Consistency Plan and the ILO have made the recommendation, and the amendments is to try to comply with all these international instruments, and also to provide protection against discrimination and forced labor, and to provide for maternity benefits. In total, if you go through the bill that has gone for first reading in Parliament, there are a total of 46 sections that have been amended. Now, I won't have the liberty to go through everything, these 46 amendments. So I have picked the relevant or the important amendments that has direct implication to the doing of business and doing of business. So firstly, you'll see the key changes is that there's an increase in. We'll go into details first, but this is just the outline. I'm just trying to discuss with you all and share with you all. Firstly, it is an increase in paid maternity leave. Later on, as we go into the details, you'll see that the maternity leave has been increased from 60 days to 90 days. This comes under Section 37 of the Employment Act. And while that is in place, the amendment also restricts employer from terminating an employee who is pregnant. This is because I think the women organizations have put pressure on this matter. Then what you find is that there's a new section been introduced to pave way for the giving of paternity leave. We'll go into the details later on. So first is maternity, then you have paternity, then you'll have employees. Now the new amendment paves way for employees to apply for flexible working arrangements. Flexible working arrangement means maybe the hours of work, the number of days, and whatnot. So we'll go into details later on. Then there's a new section that has been introduced under Section 69F, which talks about discrimination. Though this particular part is a bit very gray or very vague, the amendment doesn't tells us what do you mean by discrimination and what are the steps that has to be taken. It just briefly says that discrimination, the DG has powers to investigate when there's a complaint of discrimination, against the employee or against the employer. Okay, the next issue that we have to take note is that notice on sexual harassment. That means the employer under this section 81H, new section 81H, is to display in a conspicuous place a notice to create awareness about sexual harassment. And in this area also is very vague. They did not tell what notice it should be. Maybe later on the Labor Department of Labor will come out with some rulings or some guideline on these matters. And then another new section has been introduced under section 18A, which talks about calculating wages for incomplete months. We will go into that detail again. And then one thing that is very glaring is in this amendment is that you see that the penalty has been enhanced. Earlier, the JTK or the Labor Department believed that if you increase the penalty, this will discourage investors from investing in Malaysia. But I apparently saw that the penalties have been increased. Normally, it was 10,000, but in some cases, it is increased to 50,000. Generally, it has been increased to 50,000, but when it involves foreign workers and all that, it is increased to 100,000. This might frighten off the investors. Okay, this was the thought before the amendment. And one thing that is very, what shall I say, behind the scene is the widening of the scope. Excuse me. Widening of the scope of the Employment Act. I'm sure some of you would have gone through the amendments, and you will find that there's no mention about widening the scope. That means who is going to be covered, who is not going to be covered. We will come into that as we go on. So as what Mr. Andrew, our MC, has indicated, that we will reserve the questions towards the later part of this session. I will try to go with the slides first, and we will tackle the questions. This is a sharing of knowledge session. Please understand this. And FMM or I am not an authority in this area. It is the JTK or the Labor Department. But this session is among us. It's a sharing of knowledge. So certain things which I might not be able to answer, what I will do is I will take down and then refer the matter to the relevant authorities and then get back to you all later, if that is agreed. So to move on.
Yeah, everyone, Mr. Kesavan is still on slide 1. He was just giving an overview. Yeah, people have been asking me, are we still on slide 1? Yes, now we're on slide 2. Thank you, Mr. Kesavan.
Okay, if you look at the Employment Act, you will find that it has no definition. Part 2 talks about interpretation and definition. It doesn't have or contain what do you mean by an apprentice. All this while from 1955, 57 it came into force until now. So now with the new amendment, they have incorporated the who is an apprentice. It simply says an apprentice is a person employed under the apprenticeship contract. Very direct. Any person who's employed under the apprentice contract is an apprentice. Then when you move on to apprenticeship contract, it was already there. Now the old before the amendment, the interpretation of apprenticeship contract is where an employer takes an employee and then systematically train him for a trade. And that training, this is an important catchword here, that training must be at least for 24 months. Only then it will be deemed to be an apprenticeship contract. But with this amendment that we are now looking at, the duration has been reduced in the sense that it is if the employer can give a systematic training to this apprentice within 6 months to 24 months, minimum 6 months, maximum 24 months, it will be deemed as an apprenticeship contract. Okay. Next, you find that the domestic servant, ILO, through a few meetings, have indicated this. This is very derogatory, very like servant. It doesn't augur well for this particular this thing. So they said amend the word servant and then include the word employee. As a result of this, the domestic servant, wherever it appears in the law, has been amended to deem as domestic employee. Similarly, foreign domestic servant also the same interpretation. Now it is no more servant, it is employee. Wherever the word servant applies in the act, it is now what shall I say? It is now known as domestic employee. Okay, we move on. Now this is what is a very interesting section. Section 4, which talks about appeal. What it simply says is that anybody aggrieved by a decision of a labor officer, other than section 69, 73, subsection 81B4. I can't go into detail on this particular matter. So you can appeal to the DG. Okay, you're not happy with the decision of the labor officer, then on some permit or hours of work or something that you're dealing with the JTK and you're not happy with the decision of the officer, you appeal to the DG. And that appeal duration must be done within 40 days. Now, with this amendment, it has been extended to 21 days. But what, ladies and gentlemen, Dato, I would like to emphasize here is they have deleted section 69B and section 69C. This is where we have to observe carefully. By this deletion, 69B talks about the DG of labor can inquire into employees earning 2,000 to 5,000, because as you all know, Employment Act, the ceiling is 2,000. Above 2,000, the officers cannot inquire or this thing. But this particular section 69B empowers the officers to investigate or hear cases for those earning 2,000 to 5,000. 69C talks about indemnity in lieu of notice. So this here is also mentioned, those earning 2,000 and above can still report the matter to the labor department. By this deletion under this new amendment, what I see is that the scope of the Employment Act is going to be widened. Please bear with me. It's going to be widened in the sense that it will not be no more $2,000 and 2,000 wages, 2,000 and below. I was made to understand it will be moved to, it will be open. I mean, any employee, okay, no more 2,000, irrespective of occupation or irrespective of wages, no more Schedule 1. It says all employees will be covered. But what I was made to understand is that, but for the purposes of overtime and for other things, there will be a ceiling, and the ceiling, what I was told, will be moved up to about $4,000. Otherwise, all employees are covered under the Employment Act. So under this slide, under section 4 of the Employment Act on appeals, so there are two things for you to take note, is that the duration of the appeal from 14 days has been extended to 21 days. Please take note. And by the deletion of 69B and 69C, I gather that eventually, by deletion of this, that the Act will cover all employees. We will discuss that if there's any issue. But in this particular amendment, there is no mention of this at all. Because for your information, ladies and gentlemen, this needs an amendment to Schedule 1. And some of you are well versed with the Act. Schedule 1 talks what is the definition of employee. It talks about irrespective of occupation, those earning 2,000 and below, irrespective of wages. Okay, those who are involved in manual labor, drivers, supervisors, maids, people who are covered under the Employment Act, irrespective of their wages. This will, after the amendment coming into force, I think will no more be there. Okay, reserve your questions. Okay, this is a new section under 18A, whereby even now we still get questions in FMM, whereby employers means HR executive, HR manager, sometimes call us up and say that if the worker stops on the 15th of the month, or he starts earlier, he starts late after the first day, second day, or third day, or he resigns, or he has gone for training, or he has taken unpaid leave, how do you calculate his wages? There was confusion because whether you take the formula that is provided under section 60I, which calculates ORP, whereby wages is divided by 26 to get the ORP. So you divide it by 26 or by the actual number of days in the month. Now this new section solves that problem by giving us a formula to calculate wages of employees incomplete months of work. Okay, as I explained, incomplete can come by where he reports after the first day, second day, or third day. He is terminated, he resigns, or he takes unpaid leave. So the formula says that the denomination, please take note, the denomination is number of days of the particular wage period. Okay, if 31, you take 31, if 30, 30 days. Okay. Now, this is under section 25. I am not going to go into very much detail because they have just amended wherever the word bank appears in section 25, they've amended it to mean financial institution. And this, they claim, JTK claim, or MOH, Ministry of Human Resources claim that this is in line with the Financial Services Act and the Islamic Financial Services Act and the Development Financial Institution Act 2002. So to be in line with these provisions of this financial instruments, Financial Services Act, Islamic Financial Services Act, and the Development Financial Institution, the Act, our Employment Act, Section 25 amended, wherever the word bank appears, it is now converted to financial institution. Okay. Next, this is quite a important section. It's also in section 25, whereby the minister may order specify any approved issuer of designated payment instrument. Now, when I also was a bit confused what this whole thing means, then later on, when had discussion, it is actually meant for those like e-wallet and e-money and this kind of this thing. So nowadays it is a trend. It can be used. So the minister must approve it. Approve that issuer or designated payment instrument. Only then that can be used to pay wages. Okay. Next, employment of women. This is in part 8. Employment of women. All has been deleted. Section 34, which talks about prohibition of night work. That means a female employee cannot be employed in industrial and agricultural undertaking between the hours of 10 p.m. to 5 a.m. And in order to work, you must get the approval of the TD. ILO said this is very discriminatory towards the female employees. Please remove all this. So as a result, the prohibition of night work and then getting permit and all is been recommended to be deleted. And working underground work, okay, prohibition to this section 35 of underground work has also been deleted. Then here the minister, since the section 34 and 35 have been deleted, there is no issue of the minister making order prohibiting or permitting. So because Section 34 and 35, that is prohibition of work between 10 to 5 has been removed, and working underground has also been removed. So this Section 36 has become redundant. Maternity, as I told you earlier, pregnancy, the maternity protection has been reworded to mean pregnancy and maternity. Now, here, substituting AA, where a female employee is entitled to maternity leave. What this particular Section 37 is trying to mean is that even if the female employee is on maternity leave without any allowance, or maternity leave with allowance, she can be requested by the employer to come back to work. This sounds a bit ridiculous. Why should I come back to work? I am already on maternity leave for 60 days, and this is now 60 days. Why should I come? But then there might be some employees who maybe beside the maternity allowance, the employer might offer a salary. Beside that, I also will pay you. Can you come back or not? But on condition that set out in the thing, she must be deemed fit to resume work by the registered medical practitioner. The registered medical practitioner must certify the female employee to be fit. Only then she can come back to work while she is on maternity leave. Okay, this arrangement between her and the employer. And as widely talked about, the next one is the 90 days. This has long been championed, but now the thing is increased to 90 days. If you look at the ILO convention, that recommends 98 days. But then I think, I don't know what MOHR said. Okay, they brought it, I mean, they maintained this 90 days. This means it is cost for our employers, for our members, cost. Because within that duration, you must get somebody temporary to do the work. Despite paying the female employee who's on maternity leave, you also have to pay the female employee, the temporary employee who has been temporarily employed. You have to pay her as well as the female employee who's on maternity leave. Okay, next, this restriction I've already spoke, that you cannot dismiss. This is emphasizing again a new section 41A, where a female employee is pregnant or is suffering from any illness arising out of the pregnancy. It shall be an offense for the employer to terminate, except on breach of condition of the contract under section 13.2, breach of contract, misconduct under 14.1, or closure of the employer's business. Under this situation, you can dismiss the female employee. And this is, please take note that if you dismiss the employee and she reports to the Labor Department, the burden is on you to let the department know that you did not dismiss her because of pregnancy or illness. The burden shall rest on the employer. You should prove, okay, why you dismiss her, and it shouldn't be on this thing, or on the thing on pregnancy. Any other reason that has already been stated, willful breach, misconduct, closure, yes, no issue. Otherwise, no. Domestic employee, please, Dato, Tantri, you all might have domestic employee. Please take note of this section. The word basically from servant has been changed to employee. And what I would like to take note is that within 14 days, you hire a domestic employee, you must let the DG know. These are the important key in this particular slide. At the same time, when the foreign domestic servant, this is a foreign domestic servant, is terminated, the contract is terminated, you also must inform the DG. No, this is employment of the foreign domestic servant. You must let the DG report to the DG within 30 days of the employment. And look at the penalty. An employee who contravenes subsection 1. Why I highlighted this is because most I think almost all of you might have servants. So I think you should take note of these provisions. 57A, 57B. Okay. If the service of the foreign domestic employee is terminated by the employer, by the foreign domestic employee, upon the expiry of the employment pass, you must, or repatriated or deported, you must inform the DG within 30 days of the termination of service. This is basically on the foreign as well as the local domestic servant now. Sorry, employee. The word still comes out servant. Okay. For the purpose of paragraph 1B, termination of service of a foreign domestic employee includes the act of the foreign domestic employee absconding. Also, you have to inform the DG, and the fine is 50,000 ringgit. So basically, what MOHR has done is that they have enhanced the penalty. That is from $10,000 to 50,000. Most of is now 50,000. Okay, hours of work, please take note, this is a very, very important and also has a lot of bearing on our mode of operation, whereby the hours, 48 hours has been reduced to 45. Okay, please take note. And even when it involves shift work, it is also, this is section 60C, which talks about shift work. It also must be 45. No more 48. So if you want to average it for shift workers, you want to average it within 3 weeks, it still must come to 45 in 1 week. Average number of hours worked. Okay, then the new provision, it says that minister may make regulation relating to the entitlement of allowance during shift work. Okay, he can come out with regulation. There's a provision here. Okay, here is sick leave. Now, I don't want to go into detail on this matter, but basically, by the deletion of these provisions and all that, what it means is like this. Now, if you look at 60F, it says that the MC, okay, medical leave is 14, 18, and 22 according to the number of years you have worked with the employer. Am I right? 14, 18, 22. And then you go down further, and if hospitalization, it says 60 days. Now, before the amendment, it was if you had taken 14 days of medical leave, I mean, these 14 days will be deducted from the 60 days. That is your hospitalization eligibility. That is before the amendment. With the amendment of all the deletion, it simply means is that now it is not inclusive. The 14, 18, and 22 days is not inclusive in the 60 days. I mean, the employee is entitled to 14, 18, 20, 22, as well as if it's hospitalization, he is entitled to 60 days. This is the implication of the amendment. If you got any question, we can discuss further. Next. Okay, this is paternity leave. 3 consecutive days in respect of each confinement. And the maximum confinement is under 60FA2, it is 5 confinement and 3 consecutive days. And to qualify for that, he must be a married male employee, definitely cannot be a married female employee. He has been employed by the same employer at least 12 months immediately before the paternity leave begins. He has notified his employer of the pregnancy of his spouse at least 30 days. So these are the things, the condition in order to enable the male employee to be eligible for paternity leave. Okay. Employment of foreign employees is a bit, I wouldn't say ridiculous. They've introduced a new section 60K, which means to say you need the prior approval from the DG before you can employ foreign employee. I hope, ladies and gentlemen, with this amendments, the employment of foreign workers will be handled by one agency, not by so many agencies at the moment. Maybe the whole thing should be given to MOHR, Ministry of Human Resource, to handle it. There shouldn't be any one-stop center, two-stop center, three-stop center, or only one. That means you go into MOHR, everything on employing foreign workers should be done. So here it says that prior approval has been obtained. You have to get prior approval from the DG before you can employ foreign, and the approval, the form and approval under shall be made in the form and manner as may be determined by the DG. Upon approval, the employer shall within 14 days from the date of employment furnish the Director General with particulars relating to foreign employee in such manner as the Director General may direct. Next, the Director General may, subject to any, this is where you will come and see, you will see how difficult it is going to be. Approve an application under this section if the employer complies with the following condition. Complying with the following condition is something that we will go through and see. The employer satisfies the Director General that on the date on which he makes the application, there's no outstanding matter, decision, order, or directive issued under the Employment Act. Okay, you should not have any outstanding matter. All must be clear. Okay, in order for you to apply for foreign workers. Next, there's no outstanding matter or cases relating to any conviction. Okay, under this act, under Social Security Minimum Standard, National Wages Consultative Council Act. This is, we talked about minimum wages, 1,200, and the employer has not been convicted of any offense, okay, relating to anti-trafficking in person and forced labor. So these are the conditions you have to satisfy the Director General. It's not going to be easy, okay? But in order for you to apply for foreign workers, you must ensure that all these conditions are fulfilled so that you can apply for foreign worker. And the penalty, especially for this, one has been increased to 100,000 ringgit or to imprisonment for a term not exceeding 5 years. Please take note. Okay, termination of employment of foreign employee. This is a new section under 60 KA, not K7, KA. If the service of a foreign employee is terminated by his employer, expiry of employment pass or repatriation or deportation, the employer shall within 30 days of the termination of service inform the DG of the termination in the manner as may be determined by the DG. So simple, if you have terminated the abscond or whatever reasons, you must within 30 days inform the DG of the termination. Okay, if a foreign employee terminates his service or absconds, you also have to inform the DG within 14 days of the termination. Okay, flexible working arrangement. It simply says that the employee, this particular section, and section 60P, just says that the employee, if he wants a flexible working arrangement, has to just apply to an employer for flexible working hours regarding his hours of work, days of work, and place of work in relation to his employment. He just has to apply. And then the employer, okay, and if there's a collective agreement, the application must be in line with whatever terms and conditions that is provided under the collective agreement. So the employer, upon receipt of the application, he has to the employee shall make an application for flexible working arrangement under section 60P that was above in writing in the form and manner as may be determined by the DG, and the employer within 60 days have to either approve or refuse if you refuse, you have to inform the employee in writing that why it is in the employer's approval or refusal of the application. Don't know, this is going, maybe might be creating headache, or let's wait and see how it goes. Okay, now this talks about the Contractor of Labor. Okay, under section 69. 69 is the section that empowers the DG to inquire into complaints made by either by the employer or the employee. So with reference to this is more consequential because this is relevant to section 33, where the word principle is incorporated now, the new amendment. So in line with that incorporation, this is consequential to that amendment. Section 69 also had to insert the word principle. And fines have been increased again under section 69 from 10,000 to 50,000. And if the offense continues, another 1,000 ringgit for each day of the offense continue after conviction. Discrimination, this is something, as I told you in my opening remark, it's a bit vague. We still need to explore or ask the authorities what is this discrimination. It just simply says that the DG may inquire and decide any dispute between an employee and his employer in respect of any matter relating to discrimination in employment, and the Director General may, pursuant to such decision, make an order. So discrimination is a very wide. So if after the order, the employer fails to comply with the order, he commits an offense and shall conviction be liable to a fine of 50,000 ringgit. So what is discrimination? It is not stated in the amendment. We just have to wait and see whether the MOHR or the DG comes out with some proper guideline on this matter. This is a new section, section 69F of the Employment Act. So same thing, continuing offense, liable, not exceeding 1,000 ringgit. This is for discrimination in employment. We'll wait for the questions later. Sexual harassment, okay. Under this, the important thing to take note is that you have to put up a notice. What kind of notice, how the notice is to be, is still has to be debated. Maybe we have to wait for the DG to come out with some guideline on this. An employer should at all times exhibit conspicuously at the place of employment a notice to raise awareness on sexual harassment. Whether this is going to raise this notice is to create more sexual harassment case or reduce the sexual harassment case, we have to wait and see. This is a new section also, whereby a first-class magistrate can now, you file a case, can now hear and award the full punishment for any such offense. These are all like operational sections. And then amended forced labor. This is something also not clear. An employer who threatens, deceives, or forces an employee to do any activity, service, or work and prevents that employee from proceeding beyond the place of work. I mean, he put the worker in not giving him freedom to move, where such activity, service, or work is done, commits an offense. Okay, so in other words, this particular section just talks about forced labor, and it just confines. Forced labor is a very wide topic. It confines the thing to threaten, deceive, or forces, okay, the employee to do any activity. Okay, he's not allowed to move. So on conviction, the employer will be liable to a fine not exceeding, again, 100,000 ringgit or imprisonment for a term not exceeding 2 years. This is a new section that has been introduced under the new amendment. Okay, general penalty under section 99A has been also been increased from 10,000 to 50,000 ringgit. And then this is presumption. Presumption in the sense, why they did the presumption as to who is an employee and who is an employer. 101C. So they have identified 6 criteria, 6, how to put it, things that if it takes place, then he is an employee, or if there's other criteria that have been used, okay, then he is deemed to be an employer. I think this situation arises when you have the what shall I say? You have this vendor, what do you call them? Supplying workers, contract for labor, or supplying outsourcing. That's the right word. Outsourcing and the original workers working side by side. Sometimes it is difficult to assume who is their employer, or whether this is an employee of this particular company or employee of that particular company. So they have inserted this presumption. So when the labor officer goes and interviews and checks and finds that this particular person fits these presumptions that are provided under this particular section, then he will be deemed to be an employee of that employer. I think for that purposes, they have incorporated this particular provision. Okay. Now 102 talks about minister making regulations. Okay. There's a wide range of things here, but this also a consequential amendment, because I told you the main things are done. Like for example, prescribing the condition under which female employee may work at night. I told you earlier, section 34, working at night, has been deleted. So this provision under 102 is not necessary. It's become redundant. So and they have incorporated whatever that is to be relevant for the minister, like flexi working arrangement is a new thing. So the minister, if he thinks right or fit, he can make a regulation on that matter. So 102, ladies and gentlemen, generally gives provision to the minister to make regulation to facilitate the enforcement of the act. Okay, these are all under the regulation. And then saving and transitional, this normally takes place whereby an offense or anything that is done prior to the coming of the act will be what shall I say, will be acted upon acted upon the old act. Does not come under the new act. These are saving and transitional. And finally, HR advisory service for FMM members, email or telephone. Okay, with that, I finished my slide.
Thank you. Thank you, Mr. Kesavan.
Okay, so am I in time or over
Yes.
already?
No, you are early.
Early, I had to rush through a lot of things. I had to skip and jump. Okay, Andrew, so we'll open up the session for questions.
Yes, I think we have a few questions that people have posted. We'll take those questions first. But before that, maybe I can ask myself. Thank you for your presentation. A lot of information there. And I appreciate that you had to cover a lot. And so maybe the questions will help people clarify. I got one question divided in 2 parts.
Before you go, Andrew, you please, maybe I'm not a very computer savvy person. Let me admit that. So I hope you will help me with the chat and the questions.
Sure.
Right? So please,
Sure.
If you don't mind.
Sure.
Okay.
Alia, okay, thank you. Yeah. Okay. Yes. I will read the questions out to you. You don't have to. You don't have to read the chat box. But maybe allow me to, as the moderator, to ask the first 2 questions. You mentioned about the foreign employee. Just now, you said that, and you said that hopefully it's a one-stop shop, not a 2 or 3 or 4 stop shop. I thought foreign employees, you got to go and get immigration to approve. But now you say maybe get from Ministry of Human Resources. So which one should we go first?
No.
Immigration?
Okay, go ahead. That yeah. Andrew, is just a suggestion from me. why you have so many, you have to go here, immigration, then from immigration, you go to MOHR, and then from MOHR, you go back to the one-stop center and then get the clearance and all that. So what I'm suggesting is let's have one agency handling this. Either move it to home ministry or move it to MOHR to handle this particular thing, to avoid all the kind of allegation, whatever so. That's what I meant. But this is a policy decision that has to be made by the government.
Okay.
Okay,
Okay.
Andrew?
Thank you. My next sub question to that is that when you say foreign employees, do you also include the expatriates, or are you talking, when you talk about foreign employees, are you talking about the lower category of foreign employees?
Actually, expat,
What's the
I think
definition?
there's not much of problem, Andrew. Only the unskilled or skilled foreign workers. These are the major problematic area.
So is there a definition of foreign employees in the Act? There is.
Yes. Yes, it says that a foreign employee who is not a citizen of the country. Just one line.
So that includes expatriate lah.
Yes.
I see. Okay, maybe I have a few questions from people who have been posting when you were presenting. The first question, maybe if I can ask, is how will the Employment Act 1955 amendment address forced labor indicators spelled out in the ILO Article 29? This question is from Mr. Ang Chibun.
As I said, there's a new section about forced labor. It is still it just says that there shouldn't be any threaten, deceive, like cheating or what, or forces an employee to do any activity. It is very big and it's found in section 90B. Okay, that's all. So this, as I addressed earlier, it is still vague, very, very vague.
Okay, Mr. Ang, does that answer your question, Mr. Ang? Where's Mr. Ang? Is Mr. Ang still around?
Hello, yeah, good evening, Mike, Andrew.
Yes.
This is Ang. Okay, let me maybe elaborate a bit. There are actually 11 indicators in the forced labor, actually from the ILO. One of them is the excessive overtimes. So when I think most of the electronics companies, they will go through some ESG audits by the third party, including like the RBA, Verite. These are some of the few international bodies that will actually go in and check on the elements of forced labor. So I would like to focus on the excessive overtime. This is one of the forced labor indicators. You see, most of the time, the external party auditors will tell us whichever is stricter will be applied. So if, let's say, you look at RBA requirements, weekly working hours, including overtimes, is 60 hours, which is much stricter than the Malaysian Employment Act 1955. So how will be the so-called the amendments address this issue?
Thank you, Ang.
Yeah, thank you.
This is a very tough question, huh? Okay, we have hours of work, and then we have overtime. Okay, there's a law saying that it cannot exceed more than 104 hours. But because of the pressure from this audit from external audit that is taking place, companies are forced to follow them in order to do business. Okay, so I can't say or comment, or they cannot comment on this matter. It is whether you want to follow the law or follow the audit. In order to do business with your clients and all that, you have to follow the audit, because they are thinking that they are enforcing the international standard, Mr. Ang. Okay, is that answer your question?
Yeah. Thank you.
Thank you. Thank you. Okay, the next question, Mr. Kesavan, is what about reduction and retrenchment? Subsection C only mention closure of business of employer, that an employer could terminate a pregnant employee. This is from Veronica Lai. Do you want me to repeat the question?
What is the question, Andrew?
What about reduction or retrenchment? I think when you were talking about, I think the
maternity
one, yeah. Subsection C only mention closure of business of employer, that an employer could terminate a pregnant employee.
So, what I'm also pondering on this matter. So, redundancy and the other thing will eventually lead to closure, Mr. Andrew. In some cases, lah.
Maybe Veronica Lai, are you here? Still here? Maybe you want? Yes. Yeah. Ask your question again, please.
Yes, I think Mr. Kesavan got it. What my question, but not necessarily retrenchment or reduction in force will entail to a closure of business. So yeah,
yes.
The provisions A, B, and C are very specific, and particularly the C, it talks about just a closure. But what about the, some organizations do have reduction in force kind of exercise? Can we terminate is it legal to terminate a pregnant lady, which has got nothing to do with the reason that she's pregnant?
I see. Veron, what do you do? I'm also pondering on this matter. What you can do is maybe leave your particulars with, who is this? Andrew. Okay, I will later either email or I will call you on this matter.
Okay.
If I'm not mistaken, if I'm right, there's a provision in the main act, not this amendment, but in the main act on this. Let me check it out and then get back to you.
Okay.
Please.
Sure. Thank you.
Oh, okay. Okay. Thank you, Veronica. Next question is reduction from 48 hours to 45 hours per week. Is there a breakdown included?
Breakdown, what do you mean?
Okay.
Andrews, sorry, I'm not sure whether it's a typo error. What I meant is break time is included part of that 45 hours eventually.
I see. Okay.
Yeah, sorry.
Yes. Yeah.
Oh, is that Verona?
No, this is.
Yeah,
this is
this is doing. Yeah.
Okay, you see, even now at the moment with the 48 hours, the break time is not included. Okay, the 1 hour break time is not included.
So meaning,
so even if it's 45 minutes, the break time will not be included.
Okay,
because
so it will be based on the actual break time. Let's say the company has 2 hours break for 12 hours employee running on shift. So I could say that the net hours is 10 hours. Let's say I'm running on 4-3-3-4 shift pattern. So I would say that I'm still within 45, because if I take the net of 10 hours per day after minus the 2 hours break on 12 hours. So if 4 days in a week is only 40 hours. So is my interpretation correct? Meaning I'm still within 45 hours.
So exclude the lunch break.
Okay, all right, thank you.
If you look at section 60A, hours of work, it says that after 5 hours of consecutive work, the employer must give a break of half an hour. That's all. So you have to now think how you want to optimize the work at your workplace with the reduction of the hours of work.
But Mr. Kesavan, let me just ask this. I mean, I know but now let's say the company is given better than the Employment Act, for example. Now the total break time is actually 2 hours. We can also safely exclude that 2 hours, right?
Yes.
Okay, all right.
But you are too good an employer,
just an example, right? Okay.
2 hours break. Oh, ridiculous. Okay, next.
All right, thank you.
Okay, next one is that what are your views on maternity leave entitlement? when it is not a confinement, but a miscarriage, fulfilling the 22 weeks of pregnancy?
Even now, Andrew, without the 60 days, 90 days, if you see, if you look at the definition of confinement, it should be now, earlier it was 28 weeks, now it is 22 weeks, alive or dead, So if the female employee fulfills all the condition and she miscarriage, say after 22 weeks of pregnancy, she will be entitled for the allowance
90 days.
and the leave.
Okay, Ramesh, does that answer your question, Ramesh? Ramesh still here? Okay, thank you. There is also I think a comment from Muhammad Shohalin. Discrimination in employment needs to be properly defined. I don't know whether it's a question or a comment. So he made that comment. Discrimination in employment needs to be properly defined.
Agreed. I in my opening remark itself, I said it just says discrimination, okay, threaten, deceive, or force. So it is as what Mr. Ang said. If you look at the ILO convention on this, they have, I think, 11 discrimination, if I'm not mistaken. Okay, so where do we classify all this? Even a good example he gave was the overtime. Okay, more than 104 hours or more than 8 hours can become an issue of forced labor. Overtime can be deemed as forced labor. Okay, so as we get engaged with the Department of Labor and MOHR, maybe these are some of the things maybe people like you out there should highlight and ask the department.
Okay, Mr. Kesavan, I think those were all the questions that were sent through in the chat function. For anyone who was lazy or who haven't asked a question but want to ask, there is a reaction box at the bottom next to the share screen. Just click on the raise your hand, and then I will ask you to ask your question. For anyone who is lazy to type, you want to ask verbally? Okay, I see that there's one. Who is it?
Yeah, I'm Solihin.
Yes.
Yeah. With regards to the terminations of employee or a pregnant employee, earlier in the Employment Act sections 37(4) mentioned that any employer who terminates the service of female employee during the period in which she is entitled to maternity leave commits an offense. But this is on the current Employment Act, right? That means you can't terminate employees who are on maternity leave. But with the new amendment, meaning that even the employee on pregnancy you cannot terminate. Is it right?
Yes. That's how it is interpreted. Because why? Why the noise?
Sorry, I've muted it already. Sorry.
Oh, because what happens is that there are cases that has been reported to the Labor Department that as soon as the employer finds out that this particular employee becomes pregnant, he makes ways and means to make life difficult and try to get rid of that particular female employee. It has happened and has reported. So the new amendment is saying that, and the earlier amendment was during the maternity she can't be dismissed. During maternity, when she's off the 60 days, you can't. But here now, even during pregnancy and during maternity.
That mean it should start from the day it's been classified pregnancy.
Yes.
Confined pregnancy. Yeah.
Pregnant, and after the confinement, you cannot dismiss. So what normally employers I used to advise is that if she has conducted a misconduct, wait for her to deliver everything and then come back. And then you institute your disciplinary proceeding and then dismiss the person. But
directly not to be terminated, then get pregnancy.
Come again?
Indirectly not to be terminated, get pregnancy.
I don't understand what you mean.
No, what I mean is to escape to be terminated, then get pregnant first lah.
I hope the female employees don't get offended by what you're saying. Huh?
No. What I mean is that because in earlier sections, it is a cases where there are also misconduct happen during but
Pregnancy.
only because of those irresponsible employer. That's why this need to be protected lah.
Yes.
Yeah. Okay.
Okay,
that
thank
is
you,
just
thank you.
I wanted to get clarifications on the section 37.4. Because that
Clear,
is
huh?
my earlier understanding on that lah.
Yes, you're right. Clear? Huh?
Yep, clear.
Thank you.
Thank you.
Any other
I-
question?
Yes, I got a follow-on question who was just typed in related to pregnancy one. What if the lady did not inform the employer she is pregnant, but she committed a misconduct?
If you look at the Principal Act, they say that will not be detrimental.
Meaning?
Detrimental means the employer still have to give the maternity leave and maternity allowance. There's a provision in the Act itself for failing to inform the employer.
So she
the
still cannot.
question is different. The question is he did not know that he is pregnant, but he is actually being found misconduct.
Well, there are two situations, Charlene. I think one is that she didn't know she was pregnant. The other one is she knew she was pregnant, but maybe it's the first 3 months. She hasn't told the employer she's pregnant. One is she didn't realize. The other one is she knew but hasn't told the employer, and then in that period she commits a misconduct.
Oh.
That's technical lah.
Pregnancy is technical, my friend. I think there's no, if you look at the Act, there's nothing much. But then on the informing of the employer, there is some wording in part 9 on maternity. It just says that even if she fails, it is not detrimental to offense committed while she is pregnant. With the new amendment, I think action cannot be taken. You have to wait until the whole thing is cleared, and then you have to invoke all the disciplinary proceeding. That's my understanding.
Yeah. So what you're saying is to be safe and not to fall foul of the Employment Act. Better not terminate her lah. Whether she knew about the pregnancy or whether she did not inform the employer about the pregnancy. Better pay the salary for the 2-3 months first, and then.
But what I would suggest is that you institute the disciplinary procedure. I mean, by issuing the show cause letter and all that, and then looking at her explanation and whatnot. And then, because why? If you fail to, then the other employees who are watching you will say that you have condoned the misconduct. So at least you have it in record. When she goes for a maternity, comes back, then you can start the disciplinary action.
But the termination itself cannot happen until she comes back lah. The termination itself.
That is why I interpret it in such manner lah.
Okay. Chong Fu Ching say that then we cannot assume every lady is potentially pregnant lah. Then susah lah. Okay, thank you for your question. Okay, the other suggestion is from Mr. Ang Chibun to Dato' Andy and Dato' Sri Wong is that MSIA and the FMM please convey message to MOHR that employers are doing business in very challenging environment. As such, hopefully, capacity building among employers rather than instant punitive measures are imposed lah.
I see. Good suggestion, Mr. Very good suggestion, Mr. Ang. Okay, we will pick it up from there. Dato' Andy is there. Dato' Nathan also, I think, is participating, if not mistaken. So we'll pick it up. And to assure you, whatever forum that we are in with the relevant government agencies, especially with JTK and MOHR, we normally highlight the employers' grievances and also let them know that doing business is not easy at this present moment. So the government must try to facilitate and help the employer at this kind of time. Okay, Mr. Ang?
Okay, thank you.
thank
Any other
you.
questions?
Yeah, Andrew, I have a question, Andrew, to Kesavan. You know, I noticed that there's nothing on termination, changes in the Termination in Employment Act, because, you know, the employers find it very difficult to terminate employees. And then also about the compensation. Nothing changed there? Because like in Singapore, in US, and other countries, it's easier to terminate employees for either non-performance, misconduct, and all the various reasons. There are no changes there?
No changes at the moment, because this part of the thing also falls under the Industrial Relations Act, under Section 20, where if a workman considers that he's been dismissed without just cause or excuse, he shall make a representation for reinstatement within 60 days. So there, that particular thing about dismissal and all falls under the Employment Act as well as the Industrial Relations Act. But I totally agree with you, because when we mix with outsiders or foreigners, they say that your law is very, very rigid as far as termination and dismissal of workers. It's very, very rigid and very difficult. Okay, whereas in overseas and all that, okay, it's just a contract. That's about all. Okay, the business is back. Okay, I retrench you. Whatever payment I have to make, I will pay, and that's about all. There's no after the dismissal, Section 20 and all that does not take place. We take note, but just for your info, the amendment is not taking care of this part of whatever that you have raised. You're Mr.
Mr. Chong here. Mr. Chong here. I'm waving my hand.
Yeah.
Yeah.
Sorry, Mr. Chong. That's what I have. So to answer your question directly, there's no changes as far as termination, retrenchment, and compensation, and not. And also the Industrial Relations Act on this area has not also been amended.
Okay, thank you.
Okay.
Okay, Mr. Kesavan, there's another question from Duyin again. Can you share some details of overtime eligibility?
Oh, what?
Yes, sorry, maybe
Okay.
I can
Yes.
just elaborate a little. I think just now, in the beginning, you mentioned there will also be some changes in terms of about the, is it the cap or something about the overtime with these new changes? But I didn't share.
How do I get your name?
Duin, yeah.
Duin,
Doyin, yes.
Not DUIT, do it.
No.
That's joking.
Yeah,
Okay,
no
it is
problem.
like this. It is like this. As I told you, Section 69 and 69B and Section 69C and certain provisions are deleted, which according to me and some practitioners in this area, they say that the ceiling is going to be open. That means the Schedule 1 of the Employment Act, which defines employee, that is irrespective of occupation, irrespective of wages, will no more be there. That means what I'm trying to say, it will be open to all employees will be covered. No more 2,000, no more 5,000, all be covered. But there will be some, what shall I say, some restriction. Like you can't open it up and then the person does overtime and then base his overtime calculation on his basic pay. It's unfair and it will be very high. And cost of doing business will tremendously, as it is, I see that this amendment is going to increase the cost of doing business. Either you agree or not, with the shortening of the hours of work, giving paternity leave, maternity increase, all these will add up to the cost of doing business. You agree or not?
Yes, definitely. Yeah, that's where there's the other concern, the about overtime. Yeah. So as we know, if it's open up, that is really
coming back to your.
Yep.
So though the government realized that though they open up the ceiling, but they will have a cap. There will be some capping. They cannot leave it open like that.
Okay.
Employers will going to boil already. So let's wait, because as I told you in my earlier remark, that the amendment to the schedule will be done by the minister. That doesn't require it to go to parliament. Please take note of that.
All right.
So once all this is ready, the minister will come with the schedule, and then we have to we have to discuss on that matter.
Okay. All right. Thank you.
Yeah, clear, huh, dear?
Yes. Thank you.
Okay.
Thank you.
Next.
Okay, next one is I don't know whether it's covered, but Ms. Kesavan, you can let me know whether it's covered. Is there an update? Is there any update on COVID-19 quarantine leave? COVID-19 quarantine leave. Does the employer still have to pay as long as the quarantine is still on? Because sometimes the same employee has to quarantine 2-3 times a year, and it affects operational and business efficiency.
I see.
There's a
Anyway, this is not mentioned in the amendment, but what we normally, when employers ask us to comment on this, what Andrew, we normally say is that try to utilize the employee's hospitalization leave. Okay. Don't treat it like unpaid, but then like if he has a letter from KKM or he has close contact, just treat it. But then some of the employers are crying that employees are taking advantage in the sense that they come to the office and say, I was in close contact with my uncle positive, and then leave the employer, he doesn't know what to do. So
can I share my input with regards to this?
Yeah, sure.
Yeah, I think because currently in the stage of pandemic, that's why we have to follow government regulations that not to encourage to deduct the pay and so on. But however, once the situation become endemic and the COVID-19 is become considered as a normal disease, then any infections or none coming to work is become MC. Okay, so that is where later on we can apply the MC clause lah. But then now currently is because of the pandemic, so it's a little bit tricky on how you wanted to actually consider not working. Okay, so that is the things that is happen now. But because after this, when it become endemic, then after that is become normal sickness, none coming to work is become absence or on MC. After the doctor give it the MC lah.
Thank you.
I see.
Thank you. The person who asked the question is Zaida Tola. Did Kesavan answer your question? Maybe utilize the sick leave first. Zaida Tola? Yes. Okay. Okay. So there are no more questions. Any more? Yeah, Dato'. Yes.
Yeah, Andrew, yes, I would like to address what just now you have mentioned, as Mr. Ang also have mentioned, right? And your electronic semiconductor industry, it's actually one of the big earner for the country, as well as you have a lot of expatriate and also a lot of foreign, a lot of workers, be it foreign or what. It will not be a very conducive environment looking at it, some of this amendment, but some of this amendment may be necessary as we are subjected to ILO on this, right? And of course, this is the second or third time that I'm listening to Mr. Kesavan. I have brought it up that to also lobby that MSIA and also those other members of FMM who are also sitting there here today, listening to it, to see how this exercise, right, that we can bring forward. What I'm looking at is very much on the punitive side of it. You know, 10,000 used to be 10,000, now it's 50,000. 1,000 become 10,000, and the 90B, 100K, used to be 10,000 now for 100K or 2 years term, right? This is actually very frightening for those people who are in the who sits as director or or even as an employer. Now, Mr. Kesavan, how many more stages do we need to have on the dialogue that we can get together? Because we need to question, why is there a necessary to increase 5 times? I did make a joke out of it. Is it because our ringgit has gone down? That we have gone down 5 times, that we need to bring it up to that level? Or is it that the government need to make more money, increasing this punishment or as a deterrent? But this deterrent is very dangerous. I detected what you have just said, that if it is a summon, right, or a compound, right? Once it's a compound, you are blacklisted already, you have a case, okay? Then you cannot apply for foreign workers, for example. Just one of the simple cases that you have defaulted and you are compounded, all right? Just one simple case and that's it. Your chance of applying for foreign worker is dashed. And I look at it that this also make it very difficult for us to apply for foreign workers. A strong deterrent there to discourage us from applying for foreign workers because of the procedure, the punitive action. And I hope that this is not retrospectively or retroactively backward when this amendment. You see, some company already have been compounded. They already have problem with, I don't need to mention, they already been fined for maybe excessive overtime. They maybe been fined for other cases that you have mentioned. So these are areas that, we need to stop. We need to decide. We need to advise the government whether there is a need for such a high punishment. Is a punishment. It's already bad. All right. And today they don't summon, they compound straight away, isn't it? I notice it's a compound straight away. So once they do that, it will go straight to the AG's chamber and you cannot appeal. Basically, you have to fight through the case. And this costs time and money as well, and reputation to the company. So thank you, Mr. Andrew Chan. I'm just stating this to Mr. Kesavan that we need to address some of this issue. Thank you.
So, if you don't mind, is it possible that you use your Pemuda channel because it's a very high level kind of committee, Can it maybe have a dialogue with MOHR or JTK and then try to see whether something can be.
Yes,
it's a big
exactly. I'm trying to provoke you, FMM, MSIA, and whoever that are present here, listening to association, to group together and really be able to ask some of these questions directly to these people who are created, who are trying to, of course, maybe put everything at the max lah. But then I think these are still negotiable, right? Of course, if it is not negotiable, means that we, of course, do not expect our members to exercise their rights to use up all these privileges that they have. Okay, but we would like to comply. We would like to still do business. We would also like to make Malaysia a friendly environment, because I know that a lot of my colleagues here who are from the semiconductors industry will have a tough time trying to explain to their expatriate headquarter, their headquarter, right, that this new amendment, and this is going to frighten them, because when they sit in this country and they are going to be responsible for this, right, that means to say even the expatriate boss can go to jail if they are, and be fined. So who wants to come to Malaysia to work? That's the only thing. That is another thing. So yes, Pemuda will take it up, but I would like to take the cue from, of course, with Dato' Nathan, FMM, and MSIA on the next step. I know that today we cannot go into detail, but I just want to highlight that that this session is very good. A lot of members have brought up what exactly that I think that I fear that they will interpret. But you also have done a very good presentation by just highlighting those issues that you have gone through already. In fact, Mr. Kesavan has filtered the issue that needs our attention. Actually, there are others that I think that too small to argue about. We may have to accept. You see, if we totally reject everything, right? They will also not accept, right? We need to have a balance here. But some of the thing that you have brought out are the extreme side of it that I'm a bit afraid. The punitive side of it, the penalty side of it. Yeah, thank you.
Yes. Okay, thank you.
Thank you, Dato. Thank you, Kesavan. I think if I can add on to Dato Andy is that the government, they said that they want to make the amendment because they want to comply with TPPA as well as ILO. But in the amendments that are proposed, what actually, like the penalty and that's being imposed, is that also in compliance with TPPA and ILO? So we need to see the government, the people who have drafted the Employment Act should not use the TPPA and ILO to say, oh, we are complying with ILO and TPPA, and then make changes and take the opportunity to make some changes actually which are not mandated by ILO and TPPA. So that's my comment.
Okay.
I think
I'm sure, Mr. Andrew, this TPPA and also the ILO did not dictate how much we can penalize or the penalty, right? It is our people overdoing this. I think overzealously trying to say this is an insult to Malaysia's mentality, all right? That I think that if you have a law, be it that we have a small fine or a big fine, right? I always quote a good example. Why do you need to wear seatbelt? If you ask everybody, they will say that because the police will fine you. No, the wearing of seatbelt is to prevent you from flying through the window, the windscreen, and kill yourself or deface yourself, right? Not so much the law. So this is the same thing. You think that every proper serious investors or businessmen really want to float the law? We try our best to hire the best person or to do the best in our company. So this is overdoing it. I mean, if somebody look at it, right, they will, in their frame of mind, right, they will say, is Malaysian going crazy or currency is dropped to 5 times now, or what, that they want to increase 5 times? Or is it that the cost of living has gone up? Or government needs more money now? Example, right? I'm just quoting this.
Yes.
These are things that we need to argue. Thank you.
Yes, that's my point. Yes. I think it's yes, that's my point also. They shouldn't yes. It's nearly 5 o'clock, Mr. Kesavan. Dato Sri Wong, I'm going to end it now. Mr. Kesavan, do you want to have any last closing remarks before I end it?
Okay, a simple one. Thank you to all of you for giving me and FMM an opportunity to share on these amendments. We will try to meet at another forum, at a different place, different venue, or different time. Thank you very much. Thank you very much. Thank you very much.
Thank you, Mr. Kesavan. Dato Sri Wong, you want to have any?
I just wanted to thank again to Kesavan for his sharing, and I know that he have done great detail work in this area. So thank you very much for all the sharing, and we'll pick up some of the inputs from the attendees, and then also maybe submit something from MSIA. Thank you very much, Dato' Andisio.
Okay.
Thank you.
On that note,
Thank you.
Kesavan, Dato' Andy, Dato' Sri Wong, for your attendance and your contribution. Thank you everyone for attending today's webinar. I hope you found it informative. For some of you who have given me your emails, I'll pass it on to Mr. Kesavan. Other than that, thank you very much. Have a good weekend. Thank you for taking your time to join. Thank you very much.
Thank you, everybody.
Thank you.